understanding the general conditions of a construction contract. Over the next hour or so, we are going to be talking about the general conditions of a construction contract, particularly referencing the A201 2017 version. A few housekeeping items before we get into the substantive part of this presentation. First, you should be aware that you will be getting a follow-up email from someone at AIA National here, probably by the end of the day, which has this presentation, a PDF version of it, as well as an audio recording of it as well. If you want to listen to it again or flip through some of the slides, you'll be getting that here relatively soon. Also, this presentation does qualify for one learning unit. It's an AIA learning unit. If you registered for this program, you should be, and if you are an AIA member who's looking to get a learning unit, you should be seeing that on your AIA transcript here within the next couple of weeks. If you don't see it in the next couple of weeks, feel free to contact us and we'll make sure you get the learning units that you're entitled to from sitting and listening to me talk for the next hour. A little bit about myself. My name is Mike Koger. I am a staff attorney with the American Institute of Architects in Washington, D.C. I started my career as an architect. I went to Ball State University Architecture School in Indiana, where I grew up. And I practiced as an intern architect and then as an architect in San Diego, California, for the first handful of years of my career. Went over to practicing law shortly after becoming officially licensed as an architect, and practiced for the first few years of my legal career as a private practicing attorney. I worked in a couple of different law firms where I represented contractors, subcontractors, owners, architects, and really anyone that was involved with construction projects as their primary business. And from there, I started working with the AIA here in 2013. So I've been with the AIA for 6 years. And my day-to-day job is to work with the AIA's contract documents library, researching legal issues, working with the AIA's Contract Documents Committee to revise, update, and to troubleshoot issues with the AIA's contracts that we offer. And occasionally we do write new contracts. So if you want to get on our website, you can see all the listing of contracts that we offer. But that's what I've been doing for the last 6 years or so. And occasionally I get an opportunity to put together and do webinars like the one we've got today. I won't spend too much time talking about learning objectives. Presumably you're listening to this webinar because you've already read these and you know that you want to learn a little bit about the A201 and the general conditions of a construction contract. One other piece of housekeeping, I suppose, that I need to discuss for a few moments is the way that the AIA creates contracts. Before working at the AIA, I can honestly say that I had no idea how the AIA created their contracts. But it is an interesting process. We work with 25 to 30 volunteer AIA members who volunteer a significant amount of their free time to assist in the creation and revision of all of the documents in the AIA's library. These committee members are incredibly dedicated. They tend to spend at least 10 years on our committee. Some stick around for a few extra years as well. And we also get a substantial amount of input from outside industry liaisons and folks that are otherwise stakeholders in the construction industry. So it is not just me sitting here at a computer writing contracts. It is very much a collaborative process that involves outside advisors and a lot of input from AIA members who are volunteering their time. So with all of that out of the way, I'll turn to start talking about the A201 itself, the general conditions for the construction contract. And if you have been paying attention to our offerings over the last few years, you'll probably already be aware that in 2017, we released updated versions of nearly all of our traditional design, bid, build contracts. And that includes, for example, some of our most commonly used owner-contractor agreements, owner-architect agreements, contractor-subcontractor agreements, and the A201. The last time the A201 was updated was in 2007, so this was on our regularly scheduled 10-year cycle. And you can pretty well predict that we'll be updating this document again in 2027. Now, if you are interested in learning about some of the very nuanced things that were changed between the 2007 and the 2017 version of the A201, I'm going to talk about a few of those today, but I would encourage you to actually seek out some of the other webinars that we have done over the last few years, ever since 2017, that will probably go into some of the more detailed ways in which the A201 was changed in 2017. You can go to we actually have a YouTube page where we have entire webinars on that topic. And you can also go to our AIAcontracts.org and then the website, and then go to the Learn page of that website and find specific presentations tailored towards changes that happened in 2017. The A201 has quite a long history. It was first published in 1911, and the 2017 version of the A201 is actually the 16th edition of that document. It has undergone significant change over the years. Some things stay the same. So for example, if you're a contractor and you wonder why your A201 still says that you're obligated to clean rubbish from the site, that's probably because the 1911 version used the word rubbish. So there's some language that has just been carried through over the generations and through the many revisions of the A201. But the A201 has also expanded over time and has dealt with more complex issues over time. And the reason we have a general conditions is that design and construction projects include a large number of parties, and the resulting contractual structure can become pretty complex. The A201 offers standardized general conditions for construction that really knit together the many project relationships, roles, and responsibilities. Also, many of the important terms that are found in other documents, such as an owner-contractor agreements, owner-architecture agreements, are defined and then referenced in the A201. So it really is this repository of information in one document that coordinates responsibilities amongst multiple parties. So this is the part where I have to stop and give a little bit of a disclaimer. Actually, this is a big disclaimer. In 1911, if you were to look at that version of the A201, you'll notice, and you can actually find it on our website, if you scroll to the bottom of the page and click on the history button, you can actually see the 1911 version of the A201. It is all of 11 pages long, and it's actually got fairly wide margins, not the most complex document in the world. If you look at the 2017 version, it is 37 pages long. It is single-spaced, it has thin margins, it's got a lot of information packed in it. And it's not a long document because we like to write contracts, although we do like to write contracts at the AIA. It has become a longer and more complex document because over the last 100 and some odd years, the construction industry has just gotten more complex. If you think of the things that we deal with now on a construction project, it's vastly different than 1911, where you might have only had a couple of subcontractors. Nowadays, it's not uncommon to have dozens of subcontractors, dozens of different consultants and other parties working on a construction project. So the A201 is incredibly dense, and I only have about an hour in which to give it some justice in this webinar. It would probably take me 8 hours to actually go through all of the details and just to describe what's going on in the A201 and the different relationships. It would take me days to go into some of the stories and the rationale and the reasons why the document reads as it does. So I'm going to have to be cherry picking information a little bit. I'm going to try to give a high level overview to folks who are somewhat newcomers to understanding the general conditions of a construction contract. And I'm also going to kind of dive into some unique issues that tend to pop up that might be a little bit more nuanced, and tell you some of those stories that have led to the A201 reading the way it does today. So keep that in mind as we're going through this. I'll never get to everything, but I'm going to try to get to some of the most important stuff. And the first thing I need to do when talking about A201 is give you some basic orientation, some basic tools to navigate through the general condition and let you know how it fits in with all of the other documents that go along with the construction contract. Then I'll go into, after going through this kind of basic navigational tools, I'll go into more specific obligations, particularly of the contractor and of the architect that you'll find in the A201. And then if I have time, I'll talk about insurance and dispute resolution, two things that are always an issue, or at least are debated pretty frequently when you talk about general conditions and construction contracts. Okay, so what we're looking at right here is a table of articles for the A201. 15 different articles, and you can see it's got obviously some very important things in there. And I've indicated with arrows the things that I am going to try to talk about during this presentation. I will talk about payments and completion. I'm going to talk about insurance. I'm definitely going to be talking about correction of work a little bit. I'm not going to be talking about very important things like construction by the owner or by separate contractors. I'm not going to talk a lot about, you know, protection of persons and property, those kinds of things. One thing that I have to point out that's missing, or that should be jumping out at you from looking at this table of articles, is that while there is a payments and completions and completion section, there is nothing in the A201 about the actual price of the contract, that the contractor will be getting paid from the owner. And that's by design, of course. The A201 does not include a pricing mechanism. It is important to recognize that the A201 does not work on its own. You have to attach it or reference an agreement, a owner-contractor agreement, such as our A101, A102, and A103 documents that all have different pricing features in them. So let's take a look at how a typical contract structure works on a traditional design bid build project. Owner hires the architect using a document like B101 or B103. The architect may hire consultants. Then the owner hires a contractor using the A101, A102, or A103. And just for your reference, A101 is if the contractor is going to be getting paid on a lump sum basis. A102 is a cost plus basis with a GMP, and A103 is a cost plus without a GMP. The contractor will then be hiring probably many subcontractors. But one thing to point out about this is probably obvious to most of you, but the architect and the contractor do not have a direct contractual relationship with each other. And certainly the architect does not have a direct contractual relationship with subcontractors. What binds this all together, though, is the A201 general conditions. So from a contractual perspective, the owner and architect have agreed that the architect is going to perform some obligations that are listed in the A201. And similarly, the owner and contractor have agreed that the contractor is going to coordinate with the architect for certain activities that happen during construction. And all of that coordination is housed in the A201. Okay, so I'm going to take a moment to talk about what actually makes up the owner-contractor agreement. This is something that's quite often overlooked, but it is not as simple as the A201 plus the A101 equals the owner-contractor agreement. If it were that simple, I wouldn't talk about it for a few minutes, because there's a lot of other documents that go into that owner-contractor agreement. The general conditions is just one piece of that. And don't bother yourself with reading through this large block of text that's on the screen. I'll break it out in a little bit more manageable fashion in the next slide. But the idea is to realize that the owner-contractor agreement can be fairly complex, and it could have a number of different documents involved with that agreement. In fact, if you ever get in a dispute, if you're an owner or a contractor, and you get into a dispute and you go talk to an attorney, the first thing your attorney is going to do is ask you or take steps to figure out what is a part of that owner-contractor agreement, because from there, you will be able to figure out, or the attorney will be able to figure out what obligations flow from it. So the contract actually equals the agreement, which is the A101, 102, or 103, the conditions of the contract, which would be the A201 general conditions. It would also include the A503 supplemental conditions, if any of them are brought into the agreement. It would include drawings and specifications, both things that will be listed in the agreement. It also includes addenda, which are any changes to the contract documents that happen before execution of the contract, right? These are things that tend to happen during the bidding phase. And it also includes modifications. And modifications are changes, either changes in the work or changes in language of the agreement that happen after execution of the contract. And they can come in a number of forms: a change order, construction change directive, architect's minor change, or an amendment signed by both parties. Now I'll talk about the first three, change order, CCDs, and a minor change, in a little bit more detail in the next slide. But keep in mind that a modification can occur for a change that is not just a change in the actual construction work or the sum or the time that the contractor will be held to perform the work. These are things like if the parties decide to forego mediation, or there's a change in time limits, or something of purely a contractual nature, the parties will be able to amend the contract and can do that without going through the process of a change order. The owner and contractor just sign an amendment and change the contract. So I think that's very important to understand, and you get that definition of what the contract is from your A201, that very first section of the A201 that I just had up on the screen. For changes in the work, there are, like I mentioned before, there are three different ways that you can actually change the scope of the contractor's work: change order, construction change directive, and a minor change. And I've tried to break it out here a little bit on this slide to show what parties need to agree in order to get yourself to one of these mechanisms. So a change order is an agreement by the owner, contractor, and architect in the scope of the contractor's work. Also, an agreement on an adjustment in sum that the contractor will receive and the time by which the contractor has to perform the work. So quite often we get questions here at AIA where folks say, someone will call us up and say, an owner might call us up and say, hey, the contractor won't agree to my change order. If that's the case, then you don't have a change order. You're more in a situation of a construction change directive because you do not have full agreement by owner, contractor, and architect. Also, we have folks call us up and say, hey, the contractor says I have to do a change order, that whatever I've asked them to do is going to be a change order. Well, again, a change order is an agreement by all three parties, so you have to have the contractor can certainly propose a change order, but unless all three parties agree to it and agree to the scope, time, and the change in contract sum, you don't actually have a change order. Which takes us to our next item, which is the construction change directive. And this is essentially it is an owner's order to the contractor to perform work without full agreement on the adjustment of time or the contract sum. And while it might seem a little bit unfair to the contractor that they have not agreed to the adjustment in the price or the time, it is really an important tool to keep a project moving forward. If you're an owner and you want to make a change to, for example, type of hardware or something in your project, and the contractor hasn't agreed to the price increase for that, you still need a mechanism to keep the project moving forward. So the construction change directive orders the contractor to go ahead and make that change, and then there are mechanisms in the A201 to actually adjust the sum and the time in a fair manner or in a manner that's agreed to by the parties later on. So this is a pretty powerful tool for the owner to use to direct the contractor to perform work without full agreement on adjustments in time and price. There are some limitations to this power, and the most important limitation is that the change has to be within the general scope of the contract. You know, if you're an owner and you've hired a contractor to do a garage addition onto your house, and then you give them a CCD to create a second story addition onto the home, that's not really within the general scope of the contract, right? That's a huge addition in scope and would not be an appropriate amount of work to be adding to the contractor's scope via a construction change directive. Okay, so we've established now that the owner-contractor agreement includes a bundle of documents. The A201 is really the nerve center and is probably one of the most important documents in that owner-contractor agreement. But how do we parse out information amongst those many documents and determine, what happens if there are differing levels of detail? A lot of folks, if you were to just casually ask them if they're involved in the construction industry, they might say, well, there's an order of precedence, right? Specifications control over drawings, or the owner-contractor agreement controls over drawings or specifications, something like that. Well, if you look at the A201, that's not the way it is set up. It is actually set up that the intent of the contract documents is to include all items necessary for the proper execution and completion of the work by the contractor. And the contract documents are complementary. So it is required of the contractor to not try to force some order of precedence, but to try to read all of the contract documents together and figure out what is required of all of them. If they have a question, of course, they'll be going to the architect to answer questions of interpretation amongst the contract documents. And as you can tell from just the first part of this presentation, preparing the A201 document can be quite a challenge. The AIA also publishes a guide for supplementary conditions, which provides guidance and model language for unique project issues in both the general conditions and the owner-contractor agreement. So let's say, for example, that you are the owner is an entity that is tax exempt for some purpose. Maybe they're a school or a religious structure. There is language in the A503 guide for supplemental conditions that you can pull into your A201 to take that nuance into account. And of course, the A201 also works in complement with specifications, right? This diagram shows the relationship between the A201 and other documents that constitute the contract documents. In this case, it's the specifications. Each document provides greater detail, so the A201 provides general definitions and describes overall responsibilities. The supplementary conditions provide information that is more project-specific. And then Division 1 of the specifications provide very detailed information such as distribution requirements and review procedures. So putting together all of this package of documents can be a bit complex, and of course I would recommend working with an attorney in order to do that and to make sure everything is coordinated properly. So let's now turn and talk about some very specific contractor requirements. And I'm going to talk specifically about getting paid, completion, correction of work, and warranty issues. If you are a contractor, getting paid is incredibly important. You have subs and suppliers to pay within a relatively short time after you've received goods from them, and you need to make sure that you are getting paid from the owner on time and in full amount. So the A201 sets up a process for the contractor to get paid. It requires actions from the contractor, architect, and the owner. It all starts with the contractor putting together what we call a schedule of values. It then goes to the contractor to create their first and then subsequent applications for payment. That goes to the architect who certifies payment, and then that goes to the architect or to the owner who actually makes payment to the contractor. So let's break that down in a little bit more detail. So the first activity of the contractor is to allocate the entire contract sum in a schedule of values. If you're familiar with our documents and you've been around construction projects for a while, you'll know that G703 is the document that most folks use as a place to create their schedule of values and then insert amounts that will be due for each draw. And you should be creating a new G703 with updated numbers for every payment application. The schedule of values themselves, the numbers in there, they'll probably stay the same, but the amounts that will become due for each pay period will obviously change. And the schedule of values is the way in which the architect reviews applications for payment. It is a convenient tool for the architect to be able to go out on the site and say, yeah, about that much concrete has been poured during this last pay period. We believe they're entitled to payment. And the contractor must submit changes to the schedule of values to the architect if money is kind of pushed around from one item to the next. The A201 requires the contractor to submit those changes to the architect so the architect knows for future review of payment applications that that money has been moved around in the schedule of values. The next step is for the contractor to put together an application for payment using their schedule of values. And by the way, on our website and also on our YouTube page, we have entire webinars, hour-long webinars and programs that specifically deal with schedule of values and putting together your applications for payment. So if you have any questions about the nuance of that, they can be a little bit tricky, particularly to newcomers. I would encourage you to go to our website and look at one of those more in-depth presentations. But the contractor's responsibility for each application for payment is to submit to the architect their application 10 days before the date of payment. At least that's what the A201 says. That can be edited if you want to change those timing periods. But the idea is for the contractor to submit to the architect an application 10 days before payment. And according to the A201, the contractor should be including in their payment application completed work or amounts that represent completed work and materials and equipment that are stored on site. So that is the general structure of how A201 contractor payments are made, or entitlements to payments are made. Now, there are some provisions in the A201 that can allow the contractor to get paid for materials that are off-site, but that has to be approved in advance by the owner. So it's a possibility, but unless you've gotten that approved by the owner, you should only be including in your applications amounts for completed work and materials and equipment that are on-site. And another thing that's important about each application for payment is that when the contractor submits it to the architect and eventually to the owner, the contractor is making a couple of very important warranties. First, they're making a warranty that title to completed work passes to the owner at each payment application. And second, that completed work is free of liens and claims. I'll get into a little bit of why that's important here in just a moment. The next step in the process is within 7 days after the architect receives the application for payment, the architect has to take action on that application for payment. Typically, the architect is going to certify full payment, but it's possible that the architect, based on their site observations, could certify partial payment or withhold certification. And the architect's certification is a representation that the work has progressed to the point indicated and that the contractor is entitled to payment. So there are some caveats to that statement. It is a representation, just as I mentioned, but the architect, of course, is not obligated to be on the site at all times and to, in fine detail, audit the amount of work that the contractor has performed. And I'll get into some of the architect's specific responsibilities when they're during contract administration and during construction. But the A201 does include some disclaimers here about the architect's representation. For example, the architect's issuance of a certificate for payment is not a representation that the architect has made exhaustive or continuous on-site inspections to check for the quality or quantity of the work. This is based on the architects, to the best of their knowledge and belief, that the work has progressed to the state indicated. So that is some protection for the owner, that they've at least had the architect involved in reviewing what's out on site when they make payment. The next step in the payment process is for the owner to make payment. Once the architect has certified the application for payment and submitted it to the owner is then obligated to pay the contractor in accordance with that certification. And once paid, the contractor has an important responsibility. The contractor is required to pay each subcontractor the amount to which the subcontractor is entitled. And the owner actually has a right, once payment is made, to request written evidence from the contractor that the contractor has properly paid subs. The owner can even contact subcontractors to see if they've been paid if the contractor doesn't provide that level of evidence that they've been paid. Frankly, if you were to read the A201, it would come across in some sections as if there's a bit of paranoia about subcontractors and subcontractors not getting paid, right? We've already talked about a few provisions in which there's something of what seems to be a bit heavy-handed, where the contractor is required to pay each sub an allocated amount, and then the owner can even check up and request evidence. So why is it that the A201 seems to be a little bit paranoid with subcontractor payments? I'm going to show you a good example here. Just a second. Okay, so the example is illustrated by a case that we get out of the Supreme Court of Iowa all the way back in 1968. This is Lumber Supply Incorporated versus Hull. Hull hired a contractor named Hunter to build a house for Hull, the Hull family. The Hunter then hired a number of suppliers and subcontractors to do work on the project, one of which was Lumber Supply Incorporated. So during construction, of course, Hull pays Hunter on a number of different intervals, but one of those intervals was $18,000 for general construction services during a particular pay period. Hunter then pays, out of that $18,000, they pay $5,000 to Lumber Supply Company, and then the other $13,000 they send off to other suppliers and subcontractors. What happens from here is things get a little bit muddled. Lumber Supply actually was owed $14,000 of old debt by Hunter, the contractor, and instead of applying that $5,000 directly to the Hull contract, they apply it to the oldest debt that exists. So in Lumber Supply's mind, they got paid for old debt when they got a $5,000 check from the contractor. They did not get paid for the construction on the Hull house. So Lumber Supply goes and makes, not only do they probably sue the general contractor, they also brought a lien claim against the owner of the home. To the owner of the home, Hull, they were, you can see why this would seem very unfair, that they paid the contractor, but the contractor has not properly paid Lumber Supply. So the question then becomes, did the $5,000 to Lumber Supply apply to the Hull debt, or was it okay or acceptable for that subcontractor to apply that $5,000 payment to old debt? And that's where we get the language that's at the bottom of this slide. And this is how the Iowa Supreme Court and other courts, this is not a special case. There are other cases that are just like this. But they ruled in favor actually of Lumber Supply. And it says, in the absence of anything appearing as to the source of the funds from which a subcontractor makes a payment to a material man to whom he is indebted on account of several obligations without any direction as to application, the payment may be applied by the material man to any obligation. So that scenario right there, a lien claim coming from a subcontractor or a supplier back to the owner of the project, is why there is so much language in the A201 about lien claims and payments being specifically directed from contractor to subcontractor for that portion of work that was performed. Again, this is one of those many nuanced stories that goes into the development of the A201 throughout time, but it does try to focus on these common issues that pop up on a construction project. Next is the completion process. There is a fairly detailed procedure for the contractor, architect, and the owner to all play a part in with regard to completion. It starts by the contractor initiating the process by giving notice to the architect that it has achieved substantial completion and has a list of work that still is remaining to be done. The architect then inspects and certifies substantial completion. There is a punch list of work to be remaining that the contractor is obligated to perform before achieving final completion. Then final completion happens. The architects will inspect and certify a final payment. And then you have the contractor being obligated to provide quite a few turnover documents. Then we start the correction of work period, or then it moves on to the correction of work period, which actually starts at substantial completion. So let's go through that in a little bit more detail. Substantial completion, if you don't already know, is the stage in the progress of the work when the work or a designated portion thereof is sufficiently complete in accordance with the contract documents so that the owner can occupy or utilize the work for its intended purpose. If you're using one of our contracts to certify substantial completion, that would be the G704. That is a document that is completed by the architect and is also contains signatures from the owner and contractor. And substantial completion, the importance of it cannot be understated. Quite a few events are triggered by substantial completion, such as that certificate will often have allocations for things like insurance, security for the site, maintenance, and utilities. They all will be apportioned responsibility in the G704, and often that is the time in which responsibility goes from contractor to owner. Also, typically warranties will start at substantial completion unless otherwise stated, and contractors will know that substantial completion is also the time that retainage that has been withheld since the beginning of construction will be released upon substantial completion. So in many ways, substantial completion is a more important milestone in a project than final completion. Which leads us to final completion. We have a fair amount of folks who call into our offices to ask, all right, well, I found the substantial completion form. Where's the final completion form? What number is that document? Well, the answer is we don't have one because, well, there are some reasons. I won't get into the historic reasons why there's no final completion form, but really the responsibility or the final completion is achieved really through the architect's certification of the last application for payment. And in order for final completion to actually be achieved, the contractor has to do a number of activities. And these are all located in the A201, but they have to complete an affidavit of payment that they have paid their subs. Again, that idea of trying to protect the owner from lien claims from subcontractors. The contractor also has to complete statements and certificates about ongoing insurance. They have to get consent of surety to final payment if there is a surety bond on the project, and also provide documentation about special warranties. Okay, so after completion, we move into what's called the correction of work period. And I put these two provisions, section 12.2.2 of A201 and section 3.5 right next to each other because people get these confused on a pretty regular basis. A lot of folks actually call the correction of work period in section 12.2.2 a warranty. And it kind of serves as one. It states that within 1 year after the date of substantial completion, if the work is, if there's any defect or if it's not in compliance with the contract documents, the contractor shall correct the work once the owner has given notice. And so it really does act as a 1 year post substantial completion warranty period. But using the term warranty for the correction of work period can be a little bit confusing because in section 3.5, the A201 also has a handful of warranties. For example, that the materials and equipment will be good and of good quality and new, that the work will conform to the requirements of the contract documents and will be free from defects and so on. So how do those two provisions work together, and are they conflicting? That's an issue that has been raised in a few legal cases over the years. It's very well settled law at this point, but let's go into some of the how those different provisions work. And to do that, let's talk about a case from Louisiana that was published in the mid-2000s, and that is Mount Calvary Baptist Church versus Williams Construction Company. Fairly simple case, nothing too nuanced about it. Williams Construction Company was hired to construct a church. By the way, it's not the church that is in this picture. That's just a nice picture I found on the internet. But Williams was hired to build a church by Mount Calvary Baptist. And substantial completion was finished in early 2002. They used an AIA contract, the earlier version of the A201. And pretty much as soon as substantial completion was achieved, there were leaks throughout the building. But the owner, Mount Calvary, never notified the contractor that there were leaks. They were trying to deal with them on their own for a while, until about August of 2003, where finally the owner decided that they were going to notify the contractor and request correction of the work. So here we are, clearly 1 year after substantial completion. We are now entirely out of that 1 year correction period. So what are the contractor's obligations at this point? The contractor, Williams, argued that it's out of the 1 year correction period, and they even furthered the argument that at this point they don't have to do anything and that they are off the hook for the leaks that were plaguing this church. And in some ways, they're right. In some ways, Williams was wrong. So yes, they are out of the 1 year correction of work period. They are no longer obligated to come back and fix the leaks on the church. But that doesn't mean that section 3.5, the warranty in that section does not apply. Remember, that said that the work was going to conform with the contract documents, that there won't be defects in the work. That still applies. So the court correctly said that the 1 year period for correction is in addition to those relating to the contractor's warranty under subparagraph 3.5.1, which is a separate obligation. Practically speaking, this means that Mount Calvary, the owner, cannot require Williams to come out and fix the work, but they sure can sue them and get damages for the loss or for the amount to correct the work by a separate contractor. And that is an obligation that continues until either a statute of obligation or statute of repose or a statute of limitations is achieved. Certainly none of those were achieved after just a little bit over a year into the project. Next, I'll talk a little bit about concealed or unknown conditions. Frankly, this is my favorite topic to talk about when discussing the A201 and general conditions. Most contractors that I've talked to have a colorful war story about a project that they worked on where they started digging around in the dirt and they uncovered something that was a surprise, whether that's human remains or, some toxic materials or something. Pretty much every time you dig in the dirt, there's the potential to unearth something unexpected. So the A201 does take that into consideration and has a very thorough procedure that the parties are supposed to follow if they find something that is unknown. Most projects are going to have some level of geotechnical engineering, land surveying. So it's not that you don't know anything about the subsurface conditions or unknown conditions. It's just that there's a certain amount of information is going to be hidden until you actually start digging around in the dirt or tearing apart an old building in order to do a renovation of some sort. So the A201 sets up a process to assure that problems are addressed and resolved as quickly as possible and to allow the work to proceed. Often work stops in the area when unexpected conditions are found. The A201 obligates the contractor to provide notice to the owner and architect and for the architect to act. It does not require that the contractor provide an estimate of the cost or time impact with the initial notice. And the A201 2017 actually requires the contractor to notify the owner and architect within 14 days of knowing of a condition that was concealed, or of learning of a condition that was concealed or previously unknown. If conditions, once the architect comes out to the site and investigates, if conditions are materially different from reasonable expectations, the architect makes a recommendation for adjustment in time or contract sum. If they do not materially differ, then the architect notifies everyone that no adjustment will be made. Of course, once the architect does this investigation and makes a determination, if the contractor is dissatisfied with the result, they can always make a claim. So I've got about 10 minutes left, and I will try not to go over, but I do want to talk about some of the architect's obligations in the A201. To give you an idea of how important it is for architects to understand the A201, the word architect is used 270 times in the A201. And this is really the only AIA document where significant details regarding the architect's responsibilities are spelled out in a document that the architect is not a party to. You will find the obligations for the architect in the architect's owner-architect agreement, the B101, and there is heavy coordination that goes on between the B101 and the A201. In many ways, they say the same thing with regard to the architect's responsibilities during construction. In the B101, it is a directive to the architect to perform those services. In the A201, it is a way to tell the contractor what kind of services they can expect from the architect. But what happens if the owner and the contractor modify the architect's responsibilities in the A201, but they don't change them in the B101? That is something that happens somewhat frequently, and if at all possible, should be avoided. The B101 actually says that those modifications do not affect the architect unless the owner also agrees and amends its agreement with the architect. So if you're changing architect responsibilities in A201, you want to make sure to change those responsibilities in the B101, or else there will be a conflict of what the architect is going to provide and what the contractor will expect the architect to provide in that A201. Here's a real quick snapshot of what the architect's responsibilities are during construction. One of the ways we kind of summarize all of these responsibilities are that the architect is considered to be doing contract administration on behalf of the owner. If you ever hear that phrased as construction administration, that's a little bit misleading. It really should be contract administration. The architect is going to be doing things like visiting the site and keeping the owner involved, reviewing and certifying payment applications like we've already talked about, reviewing submittals. They're also going to be doing inspection for substantial completion and final completion, and also preparing change orders and construction change directives. Probably two of the more common responsibilities of the architect is to interpret contract documents and to respond to requests for information. All of those things that's pretty much architecture 101 stuff that you learned when you were in school, but those are all responsibilities for the architect that are not only in the B101 but are also in the A201. The architect is also an important conduit for communications between the owner and contractor. Traditionally, the owner and contractor have been encouraged to discuss all matters related to the project through the architect. But nowadays, in the 2017 version of the A201, the requirement is for the owner and contractor to include the architect in all communications that relate to or affect the architect's services or professional responsibilities. There are going to be some instances where the owner and contractor maybe need to they may need to communicate about things that do not involve the architect, and that is permissible in the 2017 version of the A201. The A201 also includes language about delegated design. This is something that's very an emerging topic in our profession, and it's something that is really going to be changing over the next decade or so. In many projects, the owner and architect choose to delegate the design of specific portions of the work to the contractor. The contractor then hires its own design professionals to perform the design based on criteria provided by the architect. So we tend to think of things like elevators, curtain walls, sprinkler systems, and so on, where the architect might provide a performance specification, but the contractor's job is then to hire a design professional to to actually do the design work up to and achieve that performance specification. So there's language in the A201 that accounts for delegated design and has some language in there about what kind of reliance can be expected by the owner, architect, and contractor. And with my last few minutes, I'll talk a little bit about insurance. This is something that we changed quite significantly in the 2017 version of the A201. For the first time ever, we put the insurance requirements of the owner and contractor in a separate exhibit. So if you are looking at the A201 and looking for insurance requirements, most of those requirements are now going to be in separate exhibits to the primary agreement between the owner and contractor, which it would be A101, A102, or A103. Major types of insurance that you should be aware of that are all accounted for in the insurance exhibit to the owner-contractor agreements. Property insurance that covers completed projects and existing property. Typically, the owners are going to be the ones paying for property insurance, of course. Builder's risk insurance is a special type of property insurance that covers loss or damage to the work during construction. So this is often, again, procured by owners, but if you are using our insurance exhibit, it is possible to change that by checking a box to have the contractor buy the builder's risk insurance and get reimbursed from the owner. Sometimes contractors can get better rates on builder's risk. Commercial general liability insurance is also something that pretty much any business entity is going to have a CGL policy, but it covers third-party claims for bodily injury or property damage arising out of business operations. All contractors are going to have some level of commercial general liability insurance for instances where they get sued from third parties. And then, of course, professional liability insurance. We tend to think of PLI insurance as something that is specific to designers, like engineers and architects. And it does cover claims due to professional errors and omissions, but it is possible for contractors, if they are doing any design work, like some of the delegated design I mentioned above, for contractors to actually get professional liability insurance as well. And with that, I'm getting to the end of my time. I definitely didn't get to all of the material that I wanted to. But I got pretty darn close. Again, there's other webinars that you can look at on our website, and I would encourage you to do that. We'll continue to provide more and more webinars on general conditions as we over the next couple of years. So check back in with us from time to time. I am going to move all the way down in my slides and show you some contact information if you want to get more information from us. Here's our contact information. If you have content-related questions, go to docinfo@aiacontracts.org. If you had tech support type of issues, you can go to our docs tech support or call the numbers. We've got folks who can help you out with our software, our document software. And with that, I want to thank you very much for participating and joining in on this webinar. If you have any questions, feel free to send them to us, and we'll try and get your responses via email shortly after this program. Thank you very much.